Welcome to the Supreme Court Podcast.
Can an employer be charged for unfair labor practice for withholding union fees? This was discussed by the Supreme Court in the case of South Cotabato Integrated Port Services Incorporated versus Montefalco Jr. In this case, there was a dispute between the company South Cotabato Integrated Port Services Incorporated and Makar Port Labor Organization, the exclusive bargaining agent of the company's rank-and-file employees. The union claimed that the company withheld collections of monthly union dues that were automatically deducted from the salary of union members. This prompted the union to file a petition for unfair labor practice against the company before the regional office of the Department of Labor and Employment, or DOLE. The Med Arbiter, who is an officer in the DOLE regional office authorized to hear and decide representation cases, inter- or intra-union disputes, and other labor relation disputes, directed the company to release to the union the unremitted union dues. On appeal, the company questioned the jurisdiction of the Med Arbiter over the dispute, but the Bureau of Labor Relations upheld the Med Arbiter's jurisdiction. This was affirmed by the Court of Appeals, prompting the company to file the present petition before the Supreme Court. The Supreme Court, however, ruled that the acts the company were accused of constitute unfair labor practice. Thus, the company must be charged not before the Med Arbiter, but the Labor Arbiter. Unfair labor practice generally refers to acts that violate the worker's right to self-organization. Complaints involving unfair labor practice are under the jurisdiction of the Labor Arbiter under Article 224 of the Labor Code. There are different types of unfair labor practice under the Labor Code. Among these are restraining, coercing, or interfering with employees in the exercise of their right to self-organization. An example of this is when an employer fails to deduct union dues and assessments from the employee's salaries pursuant to a check-off provision in the Collective Bargaining Agreement, or the CBA. This check-off refers to the deduction of union fees from the employee's salary, which shall then be remitted by the company to the union. This assures unions of continuous funding. Without these funds, unions would not be effective in discharging their duties and responsibilities as the exclusive bargaining representatives of their members. Thus, it is important that the employer complies fully with the check-off provision in the collective bargaining agreement to ensure that the union can effectively advocate for the interest of its members. In this case, the company was accused of failing to remit the collected monthly dues deducted from the employees' salaries by virtue of a check-off, despite demands to turn over the collections to the union. Such act of failing to remit the collected union dues is an interference with the right of the company's rank-and-file employees to self-organization, and therefore constitutes unfair labor practice under the Labor Code, which is within the jurisdiction of the Labor Arbiter. To read the full text of this case, you may visit the Supreme Court website and search for South Cotabato Integrated Port Services Incorporated versus Montefalco Jr., GR number 235569.